Hello, everyone. I welcome you in the first module and the fourth technical session of this FTP, of which the theme is integration of intellectual property rights into teaching, research, and professional activities. Today, the topic is open access principles versus intellectual property right. And a very apt person to be deliver a lecture or a presentation on that particular topic is with us, Dr. Muhammad Imran Khan. He is an assistant professor in intellectual property law in Zakir Hussain College of Engineering and Technology, Aligarh Muslim University. He successfully introduced teaching courses on intellectual property rights for engineers, patent law for engineers to undergraduate students of all branches of engineering in Zakir Hussain College of Engineering and Technology, and another IPR and entrepreneurship to postgraduate students of engineering. He is also worked as an assistant professor in the Department of Law, Aligarh Muslim University, Malappuram Center, Kerala. Apart from that, Dr. Muhammad Imran has various research articles and research topics and chapters uh, and various other research activities. He is also a visiting faculty in teaching IPR and biosafety courses to postgraduate student of interdisciplinary biotechnology, AMU Aligarh. Now, sir, the stage is all yours. Over to you, sir.
Thank you very much, Dr. Wes. I am still learning a lot these days. It's not something that I should cherish that what I have done till now. It's to be seen that what I will achieve in future. Anyways, thank you very much for this introduction. First of all, I would like to thank Dr. Wes personally for inviting me to this FDP on intellectual property rights. They are broad themes which he has moduled into different sessions. Today, the topic given to me by Dr. Uwais is open access principles versus intellectual property rights, right? Before that, I would like to thank Dr. Seema Siddiqui ma'am also, who is the chairperson at the Department of Law, other management of Integral University, and others like Dr. Mansoor, who has also facilitated linking with Dr. Obes for this session. So thank you all for letting me on board with the Integral University. Dr. Obes, I would like to request you that how would I start my presentation, because I am not able to see any icon for screen sharing. Should I come to my
Okay.
screen automatically?
Okay, sir. At the below of your desktop, there is an option coming of present.
No, that is why I told you at that time. Uh, okay. I will do now. I will do this thing. Just excuse me, all of you, because
So you can
I'm
present also
live.
without.
No problem. I want to make it available to everyone. Dr. Wes, I'm also logging with my laptop. But the problem with
Okay,
my
sir.
laptop, as earlier told to you, was that I cannot have an access to my camera at that time. Okay, to enter the studio allow access. Okay. Let me see if I can start the presentation on my laptop. That would be very fine. Yes, this option is available with laptop, not with my phone. Anyways, so I was ready with both the things, laptop as well as my presentation. Present. There is an option here. When I click on present option, it is letting it uploading on your. Yes, it's
Yes, sir. When
uploading.
you open the option present, there is another option coming, that is slides. When you open that particular option, there is another
So
option coming, that is your computer,
okay, fine. So now
where you have to
can
upload
you?
your file.
Yes, I
Yes,
have
sir.
uploaded. Can you see now?
Yes, sir. Now it is visible. Yes, sir. It
Thank
is
you very
visible.
much. Thank you very much, and I'm very sorry for the faculties and students who are who are waiting patiently for the session to begin. So all of you must have by now. It's been 10 days or more into this FDP. All of you must have gone through the basics of IPR. Though I am very much acquainted with the basics and the advanced level of intellectual property understanding. So this topic let me know and understood open access principles also. So for this, let me do. Fine. Let me start with the more whenever I feel like I would try to discuss it with the intellectual property principles, I will be doing that also. So let us first understand what is open access. So it's a family of copyright licensing policies under which authors and copyright owners make their work publicly available. So it's something wherein you make your work publicly available. What happens in case of IPR? You actually restrict the public from that work. So IP is not something which gives you some kind of a positive right. The rights which are given to you on your intellectual creations are natural rights. Intellectual property just restrict others from the use of those intellectual creations, whether they are copyright or inventions wherein you can have patents, right? So it's the movement in higher education to increase access to scholarly research and communication, not limiting it solely to subscribers or purchasers of work. So it's a kind of a movement in higher education so that your work may have more access to scholars, it may have more access to researchers. It's also a response to the current crisis in scholarly communication. When you have you publish your work in highly reputed journals, others can only access those journals when they are being subscribed by the institute wherein they are working. So it's actually a response to that also. If we look at the history, it started in the late 1960s or 1970s. Eric and Medin and Agricola created ARPANET. They launched it for that open access movement. These are all the movements. You can see 1994, the Social Science Research Network launched, wherein you can publish your work. Then we have 1996 Network Digital Library of Thesis and Dissertations, Internet Archives. All these things are created to make your work more accessible. In the early 2000s, you can see PubMed centrally launched, and first Creative Commons license were launched, wherein I will discuss with you. There are 6 licenses under which others can use the work with certain modifications. 2000 to 2003, Tampa Principles for Emerging Scholarly published, wherein there are certain principles laid down for the publishing of scholarly works. Again, in 2003, United Nations Economic and Social Council calls for universal access to knowledge and information. Then we have Budapest Open Access Initiatives, Bethesda Statement on Open Access Publishing, Berlin Declaration on Open Access. These three initiatives were called 3 Bs of Open Access. This Budapest Open Access Initiative, this Bethesda Statement on Open Access Publishing, and then this Berlin Declaration. These are called the 3 Bs of Open Access. In late 2000, you can see NIH public access policy goes into effect, wherein the scientists receiving NIH grants, they are bound and they are asked to deposit in PubMed, that is the central PubMed Central Library, on a voluntary basis. Then Wellcome Trust also implements open access mandates for Wellcome funded research. Columbia University again came out, then University of Kansas and Case Western Reserve, they all adopt a statement in support of open access. In 2008, federal mandates take effects requiring open access for NIH funded research through deposit in PubMed Central. Harvard also mandates open access deposit of faculty scholarly work. In 2009, MIT also mandates open access deposit of faculty scholarly work. If you see, as of today, there are over 150 universities around the world who mandate open access deposit of faculty works. You see and find out whether our university also, mandates this or not. Then there are certain, tools wherein you can publish and submit your work, that like directory of open access journals, directory of open access repositories. These are all where you can go and, do this. The three Bs which I have earlier discussed with you, the Budapest Open Access Initiative that was being led on in 2001 to 2002. In 2003, the Vista statement on open access publishing have been adopted. Then in Berlin, there's a declaration on open access to knowledge in the science and humanities. So from 2003 to 2005, this initiative has been laid. What actually open access is meant? It is something which is free, which is immediately available. You can reuse that material. It is easily available. It is easily available online also, like on Google Scholars or Journal Google. Open access literature is digital. It's online. It's free of charge and free of most copyright and licensing restrictions. So normally, obviously, there is no licensing restrictions wherein you can immediately use and copy that while giving certain attributions to the authors, right? Works are still covered by copyright law. There may be certain situations wherein your work, your scholarly work can also be covered under copyright law, but open access terms apply to allow sharing and reuse. All major open access initiatives for scientific and scholarly literature insist on importance of peer review. So it's not that open access means that you write something and then you can publish it and you can make it available for the public. So it's not like say, this thing. It's all about there is a peer review there also. It can be reviewed and then obviously it is available to a larger public at once. If we look at the traditional publishing approaches, then and we can see that is open access work gives more exposure to your work. It will give more exposure to your work. You will receive more citations to your work. Like practitioners can apply your findings. Your findings can be used by other researchers. High citation rates, as I told you earlier, and then researchers in developing countries can see your work, the public can access your work, your research can influence the policymakers also. So this is all what we can see is the impact of open research versus intellectual property rights. Because in intellectual property rights, all of you must have gone through the genesis of IPR protection, right? Uh, Most of you must have gone through the genesis of IP protection, why this intellectual property is necessary, what is the rationale of IP protection. So if you go into that, and if we talk about different types of IP, please don't focus on the screen for the time being because I'm just uh, trying to explain you a bit further of how this open access movement actually is advantageous to intellectual property movement, right? So it's not against IP. Okay, even by having your IP rights on your work, on your inventions, you can still have certain open access licensing on your work. Because in IPR, you actually restricted the work. You actually make a monopoly on the work, wherein under certain circumstances, obviously your research can be used by third parties for research and development, but otherwise your research will remain restricted to you. Others cannot have access to that without your permission. And normally then you have to give the licenses and all. Open access is compatible with copyright. Obviously, I told you you can still have a copyright wherein you can reserve certain rights, obviously, and then you can open it to public for some other uses. It is very much compatible with peer review. Here also you can generate revenue. It enables you to print preservation. It gives you prestige. It's again it's a quality work. It helps in career advancement. It is also being indexed in open access journals. It's not that open access work will not be indexed and will not be able enable you to become popular and be seen in the research community, right? But open access is not open source. And as I told you, that open source applies to computer software only. It's not open content, because open content applies to non-scholarly content. Non-scholarly content means that when you log into internet, you want to know something about Aligarh, you want to know something about Aligarh, that what is famous in Aligarh, what is famous in Lucknow, and you can get a lot of data available there. So these are all open contents. When this does not applies to scholarly content. So open access is not open content. It's not open data. It's a movement to support sharing of research data. It does not mean free access. It means that you are not being charged to get access. Okay, but all rights may be reserved. So it's not free access, but it means that you are not being charged for that access. Publications. Freely available online. If you publish in open access journals, they are freely available. No charges are imposed for access. Budapest, Berlin, these statement I have already told you that how they allow these open access movement. Open access is not applicable to contents where authors expect financial compensation. There are certain situations wherein you find that the authors expect that you should give them certain revenues, you should give them certain license, and that you are not allowed to have that content. It is not self-publishing. It's not a way to bypass peer review and publication. So please don't ever confuse that it is something wherein you write anything and then you publish anything and then you submit it in online, or you make it available at any platform. It's not something like this. It's not a way to bypass peer review. Obviously, uh, that involves peer review, and thereafter, if you want to make that work open access, then you can go for that. So it's not something wherein you should avoid, because again, you have to keep in mind the concept of plagiarism. I hope and I believe that most of you have gone through, and maybe if you have not gone through, you can ask me last that what is the difference between copyright, plagiarism, and open access. So copyright and plagiarism are similar in various aspects and different in certain aspects only. So there is an overlapping certain, like copyright is a legal wrong, and this plagiarism is a moral wrong. And then plagiarism, even if you plagiarize something, you may be guilty of copyright infringement. So there is an overlapping of that also. And it is also not a second kind, it is not a kind of a second class material cut price publishing route. It's not like this, that you can publish anything which is not a quality work, and then you can go for open access publication, that okay, I am publishing this, but and you are very much aware that the work which you are publishing and you intend to publish under open access, this work is not a quality work. This work is not something which you have developed out of your own intellectual creations. Obviously, while considering all the rights of the literature review, you have consulted so many articles. You have gone through the prior art search in your field. You have gone through the literature review. You've done all the things. Then you write a research paper, and then obviously you can go for publishing and you opt for open access. So please be cautious that it is not a bypassing route. It's not something wherein you can publish anything which is not a quality content. So it's not a shortcut to publication. It is simply a means to make research results freely available online to the whole research community. So in simple terms, this is a kind of a movement I told you earlier that wherein here in open access also there are certain modes and methods of revenue generation. It's not that authors or the others publishing houses cannot make revenue if they go for open access publication. There are certain methods for that also, but the whole intention, whole purpose behind open access movement, even if you start it back since 1960, it's only to make your research available to a wider community. I will be discussing only one aspect of IPR, that is copyright. Copyright plays a vital role in scholarly publishing world. It provides authors with a set of rights and enable them to utilize their work and recognized as a creator of the work. It includes moral and economic rights, right? So, what copyright gives you? Let us suppose you come out with a research paper. You you created it out of your own intellectual creations while going through the the literature review, the prior art searching. You done all the things, and then you write a research paper and you want to publish it and you want to have a copyright on that. So what copyright gives you? Copyright is actually a bundle of rights, right? It gives you a bundle of rights. So it's again, I told you that as the IPR, copyright is again a negative right. Negative in the sense that it exclude others from the bundle of rights which it gives to you as an author. And what are the bundle of rights? Like right to republish your work, right to convert your work into another language, right to translate your work, a right to make a movie out of your work. But obviously, for that you need, the movie maker, the producer. Obviously, you grant them certain rights, you transfer certain rights to them. So these are n number of rights which are given to you when you have a copyright. And one more thing in copyright which we need to understand in comparison to other types of IP, that copyright is an automatic right. Okay, it is not something which you have to acquire. Obviously, you can go for registration. It's optional under the law. But law says, and this Berne Convention, then Universal Copyright Convention, all these conventions actually enable the creator of the work, the authors, okay, the writers, the musicians, okay, the dramatists, the lyricists, writers, authors, everyone, uh, everyone who is the producer of literary, dramatic, artistic, and musical work, they all enable these creators of the work to have a copyright. So it's an automatic right. You don't need registration, but obviously you can go for registration if you feel like that. You can go for revenue generation out of that. So, but what copyright enables you is it gives you a set of rights and it exclude others from exercising those set of rights. What means moral rights? Moral rights relate to the right to claim authorship for the work and object to any derogatory action in relation to the work. Economic rights relate to issue of ownership in the use and reuse of materials. So when we talk about copyright, there are two kinds of rights which are given in copyright law. One is moral right, another is economic right. So moral right is nothing but those right which keeps intact the authorship of any person, which protects the authorship, which protects the integrity of the author. Okay, and if we talk about economic right are something which gives you like the rights to generate revenue out of that. So when we talk about copyright term, one important thing which is important to understand here is this exclusive rights in case of copyright, it is given for a period of lifetime of the author plus 60 years. So when we say that certain work is out of copyright means the term of copyright protection has expired. So what does that mean? It means that it's only the economic rights which are expired now. It's not the moral rights. Because even after the expiry of the copyright, the moral rights will remain intact with the author. And obviously the author is died, but they will remain intact with the legal years. Obviously, you cannot, deny authorship to him, to the author, even after thousands and 2000s and multiple thousands of years. The author will remain the author. But you can use that work, you can edit that work, and you can make money out of that work. That is a different thing. So in copyright also, but you have to wait for a long period of time, right? One of the important feature under the Berne Convention is the moral right are not transferred even when the author transfers all economic right. So when we say that the in copyright that you have transferred economic right, like you go for a publication, okay, you are going for a conference, and the conference organizers ask you that the copyright in that research will be transferred to the organizers. So herein it is implied that you are not transferring the moral rights. You are just transferring the economic rights. Moral rights will always remain with you. You will always be, recognized as an author of that work. That work may be published by the organizers in some proceedings or some other form, but obviously the authorship will remain with you. Although copyright is vested in the author, an author can grant all the rights that a publisher requires. Okay, through licenses with copyright transfer as it is not necessary. If we talk about types of open access, then there are two types. This one is the gold route, another is the green route. Herein you can see that it do not charge subscription or access fee, where you are not even required to pay the subscription fee or access fee. So this is the gold route. Secondly, wherein you are allowed self-archiving or a commitment to deposit a digital copy of a publication to a publicly accessible website known as the green route. Here also you maintain peer review to preserve their academic reputations. You can recover costs by charging an author and the publication fee. Why open access? Why open access is necessary? So when it is not possible to afford the subscription fee or all needed journals, so that is why depreciating ability of libraries. Libraries are finding alternatives to keep pace with these increasing prices. Subscription prices persistently escalating at an annual rate of approximately 8 to 10%. Cost of journals is also rising faster than inflation. Monopoly of some of the publishers and escalating the cost every year. You might have, you all of you might have encountered with these things, the monopoly of the publisher, the cost of publication. Why open access? Again, investigators expect free access to the publication necessary for research and education. IT enables us for a cost-effective alternatives available if we compare it to the traditional publishing model. So it enables that. In publishing and providing access to intellectual assets at a cheaper cost. So you can provide access at a cheaper cost also. These are certain resources for locating open access materials if you want to access that. Is there any material, is there any article, research which is easily available, which is not, requires subscription by your university or by you yourself. So for that, you can go on Google or a Google Scholar. Open access content is linked directly. A directory of open access journals. I will give you the screenshot of these also. It is not just a directory, but a search content of the journals and locate suitable journals. Then subject databases on eLibrary, that is Web of Knowledge, Sociological Abstract, Bibliological Sciences, and STERS, that is Science, Psychology, and Language Search Engine. These are all search engines you will find, and I will show you the screenshot of some of the, like Google Scholar. Here you can find the link to the full text articles and repository content from Google Scholar. Then this is a screenshot of directory of open access journals. You can see these are all searchable database and browsable list. These are all open access law and political science, mathematics and statics, philosophy and religion, science and journal. All these things you can access. These are some other repositories that British Education Index, SSRN. Most of you might have heard and might be using SSRN for your literature review. DList, OpenMed, eList, ePrint, OpenDOR, Artistry. These are all UK PubMed Central. These are all which I have already mentioned some of these earlier. eThesis online. This is an online service which allows you to search for electronic doctoral thesis produced in other UK higher educational institutions. The thesis from most institutions will be free to download and print. If a thesis is unavailable, it will be possible to request that it is digitized. You can access ethos from any computer worldwide. This is the link. It replaces the British Library microfilm. These services will provide you access to the database which is available there. You can access anytime, even if it is not available, you can request that. If you compare open access and why it is important for you, obviously, for your university, there are certain advantages, like it increases the visibility and discovery of the research output of the University of Pittsburgh and its faculty. This is the example which I have taken here. These examples are taken from this ethos is actually developed by the University of Pittsburgh. It supports the university's mission of service by disseminating research results to the global academic community, and it readily demonstrates the high level of research conducted by the university to international ranking agencies and colleagues. It gives greater access to you, more scholars view and read your work, extend the global reach of your research, reduces or eliminates price, permission, barriers of subscription to journals. It gives you more progress, promotes speeds, productivity, and knowledge translation. It allows authors to share research for the public good, not only with the colleagues at the University of Pittsburgh, but around the world also. Long-term preservation in a trusted repository. Obviously, you can preserve it in any trusted repository. The repository may be of your own university, like the Imperial University may maintain any kind of a repository for that, and obviously that they have a greater impact than its impact. Open access and its impact. Get your work noticed, cite it, make your work available while ideas are fresh and new. Share your work with colleagues, publish other scholarly works, books, articles. You can get indexed in Google Scholar, Oyster, and other internet search tools. These are the tools. I have taken the the case study of University of Pittsburgh here. These are tools which are available, that Creative Commons licensing, Spark Author Addendum, Sherpa Romeo, and the scholarship at Pitts University. Pittsburgh, actually. What is Creative Commons? It's a not-profit organization that enables the sharing and use of creativity and knowledge through free legal tools. So it's a not-profit organization, and it enables the sharing and use of your creative and knowledge through free legal tools. The CC movement, Creative Commons movement, is based on the notion of some rights reserved. And what is the notion of intellectual property rights? Uh, for instance, you can take an example of copyright. In copyrights, you must have seen in books also. जब आप book when you read the first page after the title page of the book, you might see that in the bottom you may see that all rights reserved. But in Creative Commons, you see that only certain rights are reserved. So it actually provides a balance between the creators and consumers of IP, right? That is very important these days, because otherwise there is problem of access. People may not know that whose work they are using and how to get the permission to use that work. Sometimes getting permission is not very easy. This concept allows clear indication of how work may be used, reused, and distributed. So there are six type of licenses wherein you may see that somewhere it is allowed to totally use and just as it is. You just need to give an attribution to the author, and you can totally use the content as it is. No need for paraphrasing, no need for changing the content, no need for writing the content in your own language. So there are so many kind of licenses which we will see also. While here also ownership remains in the control of the author and the copyright. Ownership will always remain. They are only allowed to use that. It's not that in open access you can have access to any article which is indexed in open access journals, and you can use it as it is while having that license granted by the author, and you can say that okay, now this is something which is created by me. No, the ownership will always remain with the author. So open access is an alternative to all rights reserved. There is a standard license that make it easy for authors to share their works with some rights reserved. So these are standard licenses. I will show you the licenses also, and through the authors can share their work while restricting certain rights to them, and allowing all the rights to others. So they are not, but in copyright, when you use the term copyright, then it automatically means a bundle of rights which are only given to an author, okay, and others cannot use it. So all these rights, right to publish, right to reproduce, right to make a movie out of a book, right to make a movie out of a novel, right to make a drama, and right to perform in public places, right to broadcast, and all these rights, all are these reserved with the authors. Once we use the term copyright, it means that all rights reserved. So it allows authors to choose the term of future use, and this way it balances between open access and protection of authors' interest. These are the Creative Commons licensing terms. Attribution. Herein, you must credit the author. You just attribute to the author, and you can, as it is, use the work without any addition or without any editing or whatever. Non-derivative. You may reuse the work, but only unaltered from the original. This is another license. Non-commercial, you may not use for commercial purpose. That you can use it, but you should not use for commercial purpose. But if you use, let us suppose it's a non-derivative license, here you are allowed to use for commercial purposes. Share alike, it allows derivative works, but requires the same Creative Commons license terms be applied to any derivative. फिर आपने share alike किया, you just share alike, you use this as a license, then the other person will also be using it as a share alike. These are certain icons wherein you can see attribution, share alike, non-derivative, non-commercial, non-commercial, share alike, attribution, and non-commercial, no derivative. You cannot write. So here, what is you can see these are the licenses in public domain, wherein you can copy anything which is in public domain. You can copy and publish. Attribution required? No, no attribution required. Commercial use? Yes, you can make it for commercial use. Can you modify and adapt? Yes, you can do that. And can you change that license? Yes, allowed. In case of attribution, wherein if can you copy and publish? Yes, it is allowed. Copying, publishing is allowed. Attribution, you have to give an attribution to the author. Commercial use allowed. Modify, adapt allowed. And then if you take an example of share alike, there also there are certain rights which are given to you. And if you look at last by sorry, non-commercial, non-derivative. Herein only copy and publishing is allowed. You have to give attribution. You cannot use for commercial use. You cannot modify you, and you can go into license. These are the benefits of open access, freely available. I told you earlier. It's lead to greater citations, ensure publicly funded work is available to all. Because most of the public funded organizations, when you are applying for research project in either in centrally funded agencies or in state funded agencies like UPCST or DST or whatever, when you get a research project, and you get a research grant therein, they actually, like that your research should be, you know, easily available, and the research results should be easily available, because it enables the policy makers also, it enables the other researchers also in that way. So that is the way where these things actually get into work. For users of open access, it's a barrier free, payment free, providing access to information they need. As I told you earlier also, many funding organizations and government, when they provide research grant to investigators, they wish to have their research published open access. So whatever research you come out with publicly funded, projects, they expect that you publish in open access journal. This is the trend these days, because otherwise their research grant will not be having more impact. Also, if more public or more researchers and more investigators cannot access that research results. Universities also wants to ensure that the research they produce, that obviously the research produced by the faculty, the students, doctoral researchers, postdoctoral researchers, is showcased to the world, and their researchers are promoted. So they will bring in new funding contracts, build their expertise, and ultimately enhance the institution's reputation. Publishers also want the same way. They want to maximize the visibility of their journals, because obviously, and you all of you must agree with me on that count, that open access journals are more visible, are well known, are popular among researchers than the journals which are being subscription based journals, because the publishers also want that, and they ensure the widest readership possible, but needs this to happen in an economically sustainable way to ensure their journal survive. They actually have their model. Sometimes they charge you the article processing fee, certain things we have seen in open access journals, wherein you have to pay a high publication fee also. But there is a balance somewhere where you can find that you can publish in some other journals which don't charge too much processing fee also. But universities also should get that kind of fund reserved for researchers, for professors, for teachers, that they can use that fund to make that work published in an open access journals, because it will have both ways, not only for the researcher, not only for the university, but for the both. So it benefit both actually. Librarians are also now managing both subscription based articles and open based content, and are is a vital point for other stakeholders to consult on the developing journal landscape. Often this involves the challenges of administering policy and approach to open access across their institution. Finally, and most importantly, the researchers themselves want their research to be available to others. You also want that your research should be available to others, and to enable the widest recognition of their work. But at the same time, they also need to consider all the policies that the other stakeholders have developed. You all have to, or, see and read what are the open access policies that are at the institute. Normally, there is a lack of policy at the university level at the moment. We all are having IPR policies, we all are having technology transfer policy, we all are having faculty entrepreneurship policy. So many policies may be there, because I am talking about my university, because I have been the integral part of IPR policy development. But there is no such policy for open access. So this is all from my side. I may not have touched upon other aspects of intellectual property, but I am very much open to your questions. If you want to, have a clear, or a specific comparison of, other types of IPR, how they actually, are actually not helping the open access movement. Because in case of patent also, I can explain you by way of an example, just to take an example of a patent. If you have a patent, obviously that gives you a monopoly right for a period of 20 years. What does that mean? It means that for a whole period of 20 years, you alone have the right to make, use, commercialize, and sale, market, distribute that invention. Others are excluded when you have a patent. If you have not opted for a patent, obviously others could have used your technology even without asking for your permission. But when you have a patent on any invention, any technology, others need your permission. So, but for a period of 20 years, others cannot use it without your permission. So, obviously, with certain exceptions are there in patent law itself. There are certain exceptions, certain limitations are there on your exclusive right or on monopolistic right. But in general, nobody else can use that technology. That technology cannot be developed at a large scale by other competitors who are very much competent to develop that technology. So that actually hinders industrialization. That actually that is what I consider myself when I am talking about the positive aspect of open access. Because when you compare the 1970 Patent Act, when it came into force, till 1995, we were having only process patent provisions. We are not having product patent provision. It is because of the fact that if we allowed product patent at that particular point of time from 1970 till 1995, it would not have been possible for India to catch up the path of progress, to to move ahead in the scientific and technological advancement. Because otherwise, by giving product patent, you would hinder and you will restrict others from making of that particular product. But while giving process patent at that point of time, we actually motivate others to come forward and use that technology, make that technology by following any other procedure other than the one which is being patented by way of a process patent. So this is one particular example of a patent which I just want to explain to you in order to make you aware that how patent law, how other forms of IPs have actually, actually apparently they promote a monopoly more. It actually they promote exclusivity more rather than promoting access. So that is why this open access movement is is advantageous in these days. And this is all from my side. Thank you very much, Dr. West. If there are any questions, we can have that.
Sir, there is one particular question that is asked. What
Yes.
legal protections uh, exist for authors who wish to retract their work from open access platforms?
What legal protections?
Exist for authors who wish to retract their works from open access platforms. So that particular question is visible on your screen.
Yes, 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 I can see now. What legal protection exists for authors to wish? Actually, what I meant and what I understood from this question is what legal protections exist and available for the authors to retract their work or to get back their work from open access platforms, right? Dear Rashid, it actually, as I told you in my presentation, that whenever you are using an open access or you are making your work available at an open access journals, you are also being bound by the terms and use of that journal. So, open access journal does not mean that you are giving each and everything for free to them. It is under certain rights. It's not that all rights are reserved to you or all rights are reserved to the publishers or other persons, third parties who want to make use of your research, which is being indexed or being published in an open access journal or an open access platform. So it all comes under a license. So it has to be seen that in which particular platform you are publishing your this whatever your work or your article or any kind of content, research content. So that is governed by that the terms and use of that license. So there are certain licenses which I have explained to you. You can go in detail for that also. These Creative Commons license wherein you have wherein your content can be easily used by someone's, but if you want to retract from that, that has to be seen that whether or not it is within the the terms of use of that the open access platform. So that is to be seen. You have to be governed by that. Once it is an open access, it should remain an open access for the time being. You have already agreed. I hope I am able to answer your question.
Thank you so much, sir. There is another question, sir. Do Creative Commons licenses affect the enforcement of copyright for open access publications?
Do Creative Commons licenses affect the enforcement of copyright for open access publication? Do Creative Commons licenses affect the enforcement of copyright for open access publication? I think that Kashish wants to ask that if you want to publish your article in any journal, let us suppose it is not an open access journal, and you also want to make at the same time, you also want to be to make use of that content under any other license wherein others are used to have access to that under certain licenses. So therein obviously once you if you talk about the enforcement of copyright, so once you have a copyright, in copyright also there are certain exceptions. So it's not that once your work is having a copyright, others are totally excluded from the use of that work. There are certain exceptions in the copyright law, which we called as doctrine of fair use. Under the doctrine of fair use, your work can be used by others for scholarly purposes. And there also it is very interesting to tell you here that the other person who is making use of your work, if that person uses your work and that work is under a copyright protection, still that person does not violate or infringe your copyright. It's still very interesting. One interesting case, like uh, like in court proceedings. In court proceedings, present any you're allowed to present any quote or any content from a established or a reputed author as an authority on any point of law. Therein also, once you are doing this, you are not violating any terms of a copyright use. So copyright and all other intellectual property right, if we say that altogether they exclude others from the enjoyment of your work, it is not right to say. It is actually not right to say. It actually does not मैंने कहा, as I told you earlier, this intellectual property movement apparently looks like promoting monopoly, promoting exclusivity, but still there are certain limitations and exceptions in the IPR laws, whether it is copyright, whether it is patent, that your work can still be used by others without others being guilty of infringement. That has to be seen, that whether the enforcement of copyright for open access journals, whether they affect Creative Commons. They actually don't affect Creative Commons licenses, because Creative Commons licenses are actually being why they are being why there is a huge movement for Creative Commons, why there is a huge movement for open access. It is because people are not aware of the exceptions, the limitations in the IP laws, the limitations and exceptions in the copyright laws. People are more aware about the monopolistic nature of IP laws. They know more that once you have a copyright, you have that work for you only, others cannot make use of that work. But there are restrictions, there are certain exceptions in law itself. Law allows your work for fair use, for criticism. Others can make use of your work for research, because otherwise and we all know that while doing research, while writing articles, we do a lot of literature review.
we extract data, we extract journals, we extract papers, whether we extract it from open access licenses or whether we get it from subscribed journals, but we collect certain research in our field, then only we start doing something in that particular field. So what does that mean? That here you are allowed to use, you are not going and asking any individual author that Mr. Such and such, I am doing research in that field and can I use your work? No, 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 you still are allowed. But when you use that work, you are governed by the copyright law, wherein what you need to do, you need to give attribution. In Creative Commons licenses also you need to give attribution, but in copyright, what you cannot do, you cannot totally, get that content and then you give attribution in the bottom, in the end notes, or in the bibliographical end notes, or this references. What you have to do in order to avoid infringement of copyright, you have to create your own content. You may be influenced by the idea of that work which you are using in your reference. You may be influenced by that work, but you have to write your own content, right? In order to avoid copyright infringement and in order to avoid plagiarism also, you have to, you have to be very clear about it, that you should not copy as it is. Even rephrasing and paraphrasing is also not allowed, right? What these research tools are available, Grammarly, and there are so many tools which are available that wherein you can do rephrasing and paraphrasing. Obviously this way you can avoid plagiarism check, but this is actually not a good practice. So even if you are having a copyright protection, you are still have to follow these things. Yes, any other question?
No, sir. That's all questions.
Thank you.
Uh, Thank you so much, sir. Uh,
Thank you.
Thank you so much, Dr. Mohammad Imran Khan, sir, for your enlightening and thought-provoking session. Your insights have been incredibly valuable. We are truly grateful for the time and effort you have invested in sharing your knowledge with us today. Thank you once again, sir, for being a part of this program and for your continued dedication to advancing the field of law and intellectual property. Thank you so much, sir.
Thank you, Dr. Bess. Thank you so much.